They're the hardest water bottles to open.
Thank you. Thank you. Thank you. They save a fortune on water here.
Good morning, everyone. Thank you for being here for the 24th Annual Henry J. Abraham Distinguished Lecture. I'm Barbara Perry. I'm a professor in the Oral History Program in Presidential Studies at the Miller Center, and just want to thank everyone for being here today, and particularly all of those who are associated with the Miller Center, my colleagues, starting with Bill Antholis and Christina Lopez Guittardi Chow, and all of my colleagues who made this happen, along with those at the law school. I want to begin, as I do now, since Henry passed on in February of 2020 with his perfect Germanic timing, just before the shutdown and the pandemic. And a few months before that, he wrote out what would become the final words that he would commit to paper. And they are about his time growing up in Germany. And I wanted to share those with you today very briefly. Henry said, it was 1934, Hitler's second year in power. My parental home since my birth in 1921 was Offenbach am Main, Germany's leather goods center, where I attended an elementary co-ed public school. The bell rang for the customary 20-minute recess, and I hurried out into the courtyard with my classmates to play a bit of foosball, when one of the latter, my classmates, smashed my chin and yelled, "Dirty Jew." "What did you do that for?" I said, struggling to get to my feet. He yelled even louder, "You're a dirty, slimy Jew." Reporting the disconcerting incident to my parents that evening, I cried out, "I can't stay in this country. Please send me to America." At the age of 13, I already realized that the United States represented to me the epitome of a free society. I left my parents and younger brother in April 1937 for Pittsburgh, Pennsylvania, where I would live as a refugee with an American Jewish family. My parents and brother followed in 1939, my father's health broken in the concentration camps of Sachsenhausen and Dachau, following Kristallnacht in November 1938. Though considered an enemy alien after Germany declared war on the United States in December 41, I was drafted into the U.S. Army in 1942. I was among the 1,985 German Jews selected to form a top-secret force to help win the war in Europe. We were fast-tracked for U.S. citizenship before being sent overseas to interrogate German POWs and liberated French citizens. 7 years after I had escaped the Nazis' grasp, I returned an American citizen and U.S. Army second lieutenant to my birthplace, war-torn Offenbach, and attended a poignant service in my boyhood synagogue. I sat in a pew with my elementary school teacher, a Protestant, holding my hand throughout the liturgy. His support of my studies had cost him his job in 1934. And Henry ended, "I devoted my life and career to the study of constitutional law and history because I learned firsthand how quickly a democracy can develop into a dictatorship." And with that, I want to make the tie to our distinguished guest today, Justice Stephen Breyer. I went back to a speech, Justice, that you gave at the Holocaust Museum when it opened in 1995, just a year after you came to the Supreme Court. And this is what you said: "As a judge, I immediately think there were lawyers in Nazi Germany. There were judges. And that makes me think with considerable gratitude that in this country, this government, we think sometimes it's a little inefficient. It's cumbersome. That's true, because we've so divided power. There are so many checks and balances. There are so many protections of human liberty built into the system that we think, thank goodness. The Founding Fathers foresaw that we would in fact have divisions of power and built-in protections. If anything like what this Holocaust Museum is about ever came near in this country, you'd have to hope that the lawyers and the judges and those in positions of responsibility, and indeed every citizen, would have the decency and courage to stand up to that in the context of these institutions that are designed to protect against it." And I know that Henry would give a loud cheer, Justice Breyer, to your statement, and that you have fulfilled his wish for our constitutional system. So we're so grateful for your being here today, and thank you to Risa Goluboff for helping to attract you to the University of Virginia. And with that, I will call on the current dean, Leslie Kendrick, who will introduce the justice.
Thank you, Barbara, and good morning, everyone. On behalf of the law school, I want to thank all of you for being here. I want to thank the many people at the Miller Center who made this possible, and also all the people at the law school who made this possible. Rebecca Claff, Gary Banks, Diddy Morris, Grace Cleveland, Laurel Owens, and all of their teams for all of the work they did to bring us here today. We are delighted to host the Miller Center's Abraham Lecture and to welcome all of you and our distinguished guests to the law school today. The Honorable Stephen G. Breyer, retired Associate Justice of the Supreme Court of the United States, has lived an exemplary life of service to others and to the nation. He was born in San Francisco, studied philosophy at Stanford University, then earned a degree in philosophy, politics, and economics as a Marshall Scholar at the University of Oxford. After graduating from Harvard Law School, he clerked for Supreme Court Justice Arthur Goldberg, and during this time, he also spent 8 years in the United States Army Reserve, including active duty in the Army Strategic Intelligence Division, and he received an honorable discharge in 1965. After serving for 2 years in the Department of Justice's Antitrust Division, Justice Breyer joined the Harvard Law School faculty, where he was a renowned expert in administrative law. During nearly 15 years on the Harvard faculty, he returned to government service on 3 occasions. As an assistant special prosecutor on the Watergate Special Prosecution Force, as special counsel to the Senate Judiciary Committee's Subcommittee on Administrative Practices, and as chief counsel for the Senate Judiciary Committee. In 1980, Breyer was nominated by President Jimmy Carter to the United States Court of Appeals for the First Circuit. He was the only judicial candidate that President Carter nominated after losing the 1980 election to Ronald Reagan, and he was confirmed by the Senate by a vote of 80-10. When President Bill Clinton nominated Justice Breyer to the Supreme Court in 1994, he highlighted both the justice's long record of service and his many talents, noting that he had served in all 3 branches of government with the heart and the head of a reformer, always succeeding at what he's tried to do. His career shows that he understands how government works and how laws are really made, knowledge that's indispensable for much of the litigation which comes before the Supreme Court. Indeed, in his more than 4 decades of judicial service, which includes 14 years on the First Circuit and 28 years on the Supreme Court, Justice Breyer was known as a jurist deeply concerned with how the law works in practice and whether it lives up to its principles. For this, as well as for his soaring intellect, his patriotism, his regard for humanity, and his long legacy of service, we are proud to award Justice Breyer the 2022 Thomas Jefferson Foundation Medal in Law, which is the University of Virginia's highest honor. We are likewise thrilled to welcome him back today to discuss his lifetime of service and his new book, Reading the Constitution: Why I Chose Pragmatism, Not Textualism. He's joined in conversation today by Professor Barbara Perry of the Miller Center, whom you met earlier, and Dean Risa Goluboff, the David and Mary Harrison Professor of Law here at the law school. Risa's not only our former dean, but also Justice Breyer's former law clerk. I know we're all eager to hear this discussion, so please join me in welcoming Professor Perry, Dean Goluboff, and our guest of honor, Justice Breyer.
Thank you, Dean Kendrick. And before we begin, I would like a representative of Henry's family to stand. Philip Abraham, will you please stand and be recognized? Philip is a lawyer in Richmond and was the apple of his dad's eye, I can tell you for sure. Thank you, Philip, for being here. We also want all of you to participate. We're going to chat with Justice Breyer a bit with some questions about his book and his views on the world and where we stand in this country. And if you have questions, I understand there have been some papers and pencils passed around. Please hold those up as you come upon your questions, and staff from the Miller Center will come and pick those up from you. If you are watching online, we welcome you. And we suggest then, if you have questions, that you use the Q&A function at the bottom of your screen. With that, then, Justice Breyer, let me ask this question. Why this book at this time now? And tell us what it's about and why you were prompted to write it.
It's about the court.
How so?
Well, I mean, probably in the 40 years I was there in the Supreme Court, as you said, 28. Well, first, thank you for that introduction. I mean, it was terribly nice, really nice, really was. And the only thing I should say now is nothing.
But you'll say more.
Well, I have to do something to warn a bit of that. But
We hope.
Yeah, this thing is sort of taken over. Not taken over, but it's become very popular. And what is this thing? This thing is, what you should do is be very literal, interpreting text. What does a judge do in an appellate court? Now, you all know what judges do in appellate court, and the poor students read opinion after opinion and opinion, and they say, that's what they do. God, we don't know how they keep writing these things. And then they have to read them. But what I like to do is tell seventh graders. Great. The only one problem, seventh graders are high school students. Somewhere in there, I like to tell them what we do. Why? Because it's a challenge. Why is it a challenge? Because they're looking out the window. The judge comes here, they're looking out the window. They find whatever is out that window is a lot more interesting than what he's going to say. So I say, okay, you want to know what I want to know? They don't really, but I say, they have to. Okay, so you want to know? This is what it is. I read in a French newspaper. A biology teacher, high school, is taking from Nantes to Paris a basket. In the basket are 20 live snails, okay? So the conductor comes up, what's in the basket? Snails. Have you bought a ticket for the snails? He says, what? A ticket? It was half price. Half price ticket for the snails? He said, well, why? He says, well, read the fare book. It says no animals on the train except in a basket and with a half-price ticket. He says, what are you crazy? They're talking about dogs or cats or maybe a rabbit. They're not talking about snails. I mean, this is ridiculous. Is a snail an animal? Still, they're not talking about that. No, ridiculous. So then I turn to the class, you see, and I say, well, who's right? And at that point, I can lure them away from the window. And they say, and they get it, I don't have to say another word. Half of them say, no, that's ridiculous. You have to pay a ticket for a mosquito. I mean, it's crazy. And the other says, is a snail an animal? And I don't have to say it. I say, now you understand what an appellate judge does. You got it. I say the word might not be animals. It might not be animals. It might be the freedom of speech. Or it might be right to bear arms. Or it might be, some other words, but it's the same idea. What's the scope of those words? That is, what do they apply to this or don't they? You got it. All right? Now, to figure out the answer to that, in most cases, whether it's a statute or whether it's the Constitution itself, you see, there are a lot of things you look at. You don't just look at the words, what its history, what are the values that underlie it, what are the consequences if you decide this way or that way. But all of a sudden along has come this thing called textualism. And Nino, who I got on very well with, we were good friends. Nino Scalia used to say, you look at what those words meant to the people who were alive at the time that they wrote them, and that's it. Don't go looking at texts. Yes. Purposes? No. Consequences? No. No, just look at what they meant. That's the end of it. And I wouldn't be so worried about that where there are not so many people who seem to be holding on to it. And why is it so popular? I said, well, I can see why it's popular, because along with this advice, just look at the text, come promises. 4 promises. And if you look at a case actually like Dobbs and look at the opinion, what I had the class do 3 weeks ago, I said, go look at Alito's opinion. And I would pick out 5 words that I think are the key. And those 5 words are, too many judges just substitute what they think is good for the country for the law. So what are the promises? 1, our system, they say, is easy. Just look at the words. And you will then say, what do they mean? 2, our system will produce uniformity across the country. And so you won't have one interpretation one place, one interpretation another. 3, Congress will love our system because they will then know what judges will do with the words that they write or compromise to write or end up in the statute. 4, we won't have those judges putting in the law the things that they like or that they think are good rather than the law. Now, those are the promises. So I read that, and I think, no, that's not right. Now, what's not right? The promises are fine if they can do them, but they can't. They can't do it, and I'm going to prove it. Why do I prove it? And that's how I do it. That's over the 40 years, and she knows that. When I think something is really wrong, this is just me, and maybe just the wrong thing to do. But when I think something is really wrong, that some of the judges are doing and I'm about to dissent, I don't go and say, oh, it's the worst thing in the world. I write an opinion. And John Wisdom told me to do that. He said, when you think, and John Wisdom is one of the great judges in the Fifth Circuit who integrated the South. And he says, you write an opinion and it says how really terrible your colleagues are. And this is the worst thing ever written, and it's going to wreck the whole world. And when you finish writing that opinion, you read it, tear it up, throw it in the wastebasket, and sit down and write a judicial opinion. And so that's what I do. And I write it. If I'm really annoyed, I will try to write it in a way that even a child of 2 would say, I must be right, and the others out of their mind. See, that's the object, okay? And so there's the book. And a child of 3 might find it interesting too. But I want to say, you can't keep those promises. And even if no one reads this book, I sometimes feel in writing it, I don't know how many of you know, have seen the Book of Kells. The Book of Kells is a beautiful book. It's in the Trinity College Library in Dublin. It was written by monks on the island of Iona in the 9th century. And they wrote it, some feel, illustrated, biblical illustrations, just beautiful. And some believe they wrote it because a great darkness had descended upon Europe and they wanted to keep a ray of light. Well, I'm not saying I live up to that. But nonetheless, I say that thought sometimes occurs. And so I want to say in here, why? I think, for example, you want an example? We have a case. The case is you probably know this law, or some of you do, that there is a law that says if you have a child and that child has, disease or handicap or mental or physical, the school board has to give it special education. And if you think the school board isn't doing a good job, you can go bring a federal lawsuit. And if you win that federal lawsuit, they have to improve their education. And it says in one sentence there, it says, and you recover. The family recovers, if they win, their costs. So what was in the Supreme Court? Typical. Costs. What's costs? The woman had spent $29,000 on an educational expert. Was that part of the cost? Or was it just the cost of the lawyer? Or was it just the cost of the court? Filing fee. Oh. So I say to my friend, the textualist, okay, you want me to read the text? I'll read it. It says cost. Oh, you mean I have to read it carefully? Okay. Cost. I'll read it several times. Cost, cost, cost. Right. I said, oddly enough, I haven't gotten much further. And the cases in the Supreme Court, not everyone, but certainly almost everyone, is that kind of a case. You're going to say this is easy? Or you're going to say Congress will love it? Maybe. They're not going to know how it comes out. Okay? Or you're going to say, oh, well, you won't be able to substitute your own views for the law. Try Dobbs. I'm not criticizing Dobbs. I wrote enough in a dissent to criticize that. But Dobbs was the abortion case, and I say in there to my imaginary friend, the textualist, I will say, I see. You overruled, you realize. I think they did realize. You overruled Roe v. Wade. You overruled Casey v. Polino. How many others are you going to overrule? Are you going to rule every case that wasn't done and written in a textualist style and a textualist analysis? They're going to say, no, that isn't what we're going to do. Of course they're going to say no, because hardly any cases are written in that style, certainly not before the 21st century. And so you're not going to go out and say we're going to overrule every case as a candidate for overruling. If you were to say that, there would be no law left. And even if the lawyer didn't want to say overrule a case that's been around for 100 years, his client would say, hey, overrule it. Don't tell me I can't do this. I like doing it. And go overrule the case. You see, it would be a nightmare. And they won't say that. They're not going to say they want to say that. I say, all right, which cases do you want to overrule? Oh, the ones that are egregiously wrong? Ah. And how do we know if it's egregiously wrong? I see. You're going to tell us if it's egregiously wrong. But that doesn't leave room for you to decide whether your own view of what's good for the country is being substituted for the law. So I say on that fourth question, which is absolutely important, it's much of a muchness. I mean, each and every judge has that temptation. Every judge faces such a temptation. Don't give in to it. You can't get away from it completely. You can't prevent the fact that I grew up in San Francisco, that I went to Lowell High School, that my father worked for the school board, that I went to Stanford, and maybe I should have gone to UVA. I don't. But
Clearly.
Right. But I have lived the life I've had, and you have lived the life you've had, and all of you who are students will live the life you are given and you seize. And that's it. And you can't totally escape from that. And it will help shape you. And you might try, if you're a judge, and you should, to see what the law is. But will your own upbringing and background and what you think of this country and how you've learned to appreciate it, or what you think are its failings or faults and so forth, all those things are part of you. And you try to escape from that, you can't. So there's some role there. But you try. Try to be the judge. That's your job. You try, and you have the same temptations and the same problems, whether you're the world's greatest textualist or not. And so I don't think that fourth question gives the textualist some kind of advantage. At least I haven't seen it. Wonder what I think the argument's really about? Nino and I went to the University of Lubbock. We like to go and talk to students who maybe hadn't seen, arguing anyway, too many Supreme Court justices. So we go to Lubbock, Texas, and they filled the football stadium. I mean, I was surprised, because I thought they must think there's a football game. Nino and I were discussing this, and the audience could see. They could see from our reactions to each other that we were friends. Though we didn't think the same things about how you go about interpreting this document, the Constitution, and so forth. So I would say to Nino, and trying to emphasize that it's not a static document. Times change, even John Marshall thought. got to last a long time. So I'd say, George Washington didn't know about the internet. And Nina would say, I knew that. And then he would say, you know what it's actually like, Stephen? He'd say, it's this. He'd say, I'm not saying my system of approaching these problems is perfect. He'd say, but look, it's like the two campers. So I said, two campers? Yeah. He said, the two campers. The first camper sees the other putting on his running shoes. Why are you doing that? He says, because there's a bear in the camp. He says, a bear in the camp? He says, you can't outrun a bear. He says, yeah, but I can outrun you. So he said, the real problem with your system, and it's not my system, the real problem with the way you decide cases, and he came after a while to realize I was serious and sincere in the way I decided cases, as I think judges are, try to be. That's the job. You don't want to have that job, go and get another job. There are plenty others. Often. There should be. Anyway, he says, the trouble with the system that you tend to follow is it's so complicated, you're the only one who can do it. And I'm not sure you can. And it's too complicated. Too many things might go into this. And I say, well, I see your point. There is some truth to that. I think judges whom I've admired, I was taught in law school, Holmes, Learned Hand, Cardoza, Brandeis, others, John Marshall, they tended to follow it. He said, well, but maybe, yeah, but I don't think you follow it. and I would say, okay, I see the point. I see the problem. But we have your system. We'll have a constitution nobody would want. And who between those 2 points of view is right? I think we won't really know for 20 years, 30 years, a long time. Because there are a lot of people follow this up. And we'll see what happens. I think it won't work. But that's me. And there are a lot of others. Quite a few think it will. So I write this book. And I use examples. Do you want to know why I use so many examples? I use loads of examples. Why? Because I know that there are 4,862 law professors in this country who feel they know the whole theory better than me. so I go off on that approach, I'm dead. so what I do is I say, yes, but I have had some experience. And I'll show you my experience. I will show you with examples. So you can put your mind to those examples and you see what you think. All right, that's the book.
So I would tell you that in 2010, Nino, Justice Scalia, gave the Abraham lecture here. He had taught here as well. And I would encourage all of you to go to the internet and watch it, but he wouldn't let us film it. So, no. So you will get the eternal word because you have been completely open.
Yeah. Oh, we enjoyed going around and talking. I mean, it was...
He was great.
Yes,
he was great.
It was fun. It was interesting.
He was especially fun at the after party.
Yeah. Yeah.
All right, Risa.
So in your approach, which you call pragmatism, right? Why I chose pragmatism.
No,
not
actually, it was the publisher who chose the word.
Oh,
pragmatism.
interesting.
Ah.
What would you have said?
Well, I would have said I looked to and the underlying thing. Actually, I copied this from Holmes, but I mean it's true. You have a case. The cases are not all alike. They're quite different, one from the other. And you have to say, what are the things that are going to help me decide this case correctly? To say that these words over here have this scope, that the word a police officer in this opinion does not refer to German police officers. It refers to American police officers. It's limited in its scope. It doesn't mean. How do I come to that conclusion? Well, of course, first you read the text. If the word in the text is vegetable, that doesn't mean a fish. And then, when it's not answered by the text, which is normal, there are other things you might look to. Someone wrote those words. And someone was told by someone in Congress to write them. And they probably appear in a committee report. And they probably, if they're difficult in terms of their scope, it will explain what the committee has in mind. And the committee draws what it has in mind from testimony, which is public, and which their words. So you read these things. Now, they won't always answer the question, but they'll help. They'll help work out, because when I worked there on the Judiciary Committee, the reports were not secret. And we would circulate the report for any bill to every senator. There were 17. They all had staff on the committee, and they would receive a copy of the draft report. And they could amend it or change it. If they didn't like it, they could write a concurrence. If they really didn't, or if they really didn't like it, they could write a dissent. And they would do, in all likelihood, what their principal, the senator, wanted them to do, or what they thought they wanted him to do. And if they didn't do that well enough, they wouldn't have that job very long. So it's circulated, and very often it does help. That's the legislative history, which you will learn about. Or you might look to the values that underlie this bill, and particularly if it's Constitution. Constitution filled with these values. So what's this about? What it's about, in part, is a democratic society. We are going to have in those, I just read, what's his name, Ganapp,
Jonathan Ganapp.
a historian, good book. Yeah, he says the most important words in the Second Amendment: free state, not bear arms. It starts out by saying a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. What do they have in mind by free state? Just a state that doesn't interfere with your lives and lets you do what you want? That may be part of it. But it's also a state where the people, through a democratic process, are going to decide what laws there are. And this document doesn't tell you the answer to that. It more or less sets a frontier. It sets a boundary. There are boundaries and boundaries and boundaries, but within those boundaries, which are very broad, it is the people at the voting booth and in making up their own mind and through public opinion who will decide what the laws of the state are. That's called a free state, as well as the other. So these boundaries, I used to say when I'm back in the 7th grade class I like to talk to, I said when I was your age, I would listen to a program called, what was the name? It was about the mounted policeman. It was, what? Yes, Sergeant Preston of the Yukon. Thank you. See, I knew people were educated in this university. Sergeant Preston of the Yukon, that was it. And he was up in the Alaskan border in these places, Royal Canadian Mounted Police, and life in that police force was pretty tough. And I say, of course it is. Is abortion inside or outside? I said, that's a tough question. It's filled with tough questions. But those tough questions are the boundaries. See? And there are boundaries. But it's within those boundaries that this democratic society, which is the object here, is meant to work. And that's what this what tells you what things to look at. It depends on the case. And as you're there longer, Holmes said thus, you become wiser and better, and the future might tell you, or, I won't even be here, but people will read it. They'll know whether you were wise in this or not. I make a big point in here, the country has to work. This has to be a practical document. That's where they put it.
That's why the pragmatism.
Yeah. It has to be a practical document, and you find that in John Marshall. You find that in the founders. A practical document designed for the ages, designed to work for more than 10 years, designed to work for a long time. And that's why, which I have hard to understand, but around this basement of the Supreme Court, the first floor there, it says, Marshall's words, it is a constitution we are expounding. Yeah, it's going to last. And so that isn't just mysticism. I mean, you do it well and experience helps you, and being a judge is a job like any other where experience does help. You're dealing with people and you're trying to create a world or maintain a world that is a world that has the values that are here. So those are important. So it depends.
I always tell my constitutional law students about John Marshall's words being inscribed down there, and him, sitting in the big chair. There's a huge statue, and there's a reason, right? There's a reason he gets the big statue, and the.
Well, that statue, I think, was carved by Joseph Story's grandson.
I did not know
I think
that.
so. He was a member. Many things I know for certain as I get older, I'm completely wrong about. But it was the Marble Faun, the group of sculptors who came from the United States and artists and went to Rome. And I think St. Gaudens was one, and then they came back and produced really great works of art. I think that was his, but I'm not positive.
I'll look it up after. So I'm curious, in your approach, which may or may not be called pragmatic, but certainly is concerned with the system and how it works and making sure that it works for the people and works to maintain our constitutional democracy. Do you think that your pre-judicial jobs influenced your view of the system and the role of the judge? And that?
Yes, particularly working in the Senate. The Senate is chaos. One of your professors was telling me when she worked in the White House, she thought that was chaos, but she hadn't worked in the Senate. I mean, it was, yes, but you work there in Congress and the staff or for a while, or maybe you're elected people, but I mean, that's where the power is in this. What it was when I worked there. I worked there I worked there twice. I worked there in 73, 74, 75. I worked there also 79, 80 on judiciary. This is what, I walk into my office one day, with small offices, but adequate, and there's a young woman going through all the papers on my desk. So I say, can I help you? How do you happen to be going through all the papers on my desk? And she said, well, I'm a student, and I came in because I wanted to see what you actually did. And it seemed to me the best way to find out what you did was to look through all the papers on your desk. All right. I was getting a little angry. But before I sort of expressed my irritation, I thought, well, maybe she's a constituent. So I said, please don't. Okay. But you see, that's what that's like. I say, who would Senator Kennedy, whom I worked for, who would he have answered first? 2 phone calls, one from the mayor of Worcester, one from the Secretary of Defense. Same time, I think mayor of Worcester. Mm-hmm. See, that's where the power is, and you really feel that at the time. So when people criticize the Congress, okay, I'm sure that everything, but, and people tried to get on, and those Senate reports would help. So I said, of course, read the legislative history, and if you find it doesn't help, you don't have to follow it. But sometimes they do help, and sometimes they tell you what these words were there for. Not always. So look at it. Why not? That's.
Justice Breyer, what do you say to people who, you're drawing a distinction, obviously, between the Congress and the courts, but people who think that all judges are politicians in black robes?
No. I think that's the wrong word. Definitely the wrong word. Politics, they say, oh, all this stuff you've been talking about to the 7th grade class or elsewhere, or writing down, that's just a waste of time. It's just all politics. That isn't what I've seen. That's not what I've seen for 40 years. Well, what have you seen? Is sort of likewise. Well, there's some things I could understand why people say that, but not right. There's certainly politics in the nomination process. I think that every group interested in politics and political results, they look over the judges in the country or others who might be qualified, and they try to get the president to appoint the person they want. Now, that's really politics. And so is the Senate. But not from the point of view of the person who's appointed. You see, he doesn't think he's doing politics. He might have different jurisprudential theories or different approaches to legal problems, but he thinks he's doing law. He might have been appointed because the people who do politics think he will decide legal questions in a way, given how he has decided and thinks, that will please them politically. But that's not what he's thinking. He's thinking he's doing this according to some of the legal theory I don't like too much, but that's what they think. I don't see the politics in action there. So you might think it has something to do with what I said before, that people live different lives. They come from different parts of the country. They have had different kinds of schooling. And I used to think, I grew up in San Francisco, as I said, and I lived for many years in Boston, Cambridge. And I used to think, when I was first there, well, why doesn't everyone agree with me all the time? I'm so reasonable. And then I began to think, which is a little more mature, it's a big country. It's a very big country, 330 million people. You have every race, every religion, every point of view. My mother used to say that. She used to say there's no point of view so crazy, there isn't somebody in this country who doesn't hold it. And she said, because we're in San Francisco, she said they all live in Los Angeles. But nonetheless, it's not such a terrible thing that you have people with different backgrounds, with different points of view because they have different backgrounds, perhaps, different life experiences. Not such a terrible thing to have a court that's mixed in its approaches. That means they won't always agree with you. Okay? Fine. Not everybody in this country does or should. But people can think that's political, but I don't think it is. Or they might be political scientists. If you're a political scientist, you go and say, what do you really think of this country? What is it? What is it really? What is democracy really about? We're going to hear about that because you have an institute for that, and you have another institute for that. And what is this democracy? And what are its virtues? And how do we keep it? And so, you see, there are a lot of things in political science. They're not politics, but they are political science. Or you could have, sometimes, I think this is a political case. Miscegenation, it came out of Virginia. First time it came out of Virginia. Is miscegenation constitutional? I mean, not miscegenation, but a law forbidding it. Mm-hmm. Okay, Frankfurter said to the court, we're trying to get Brown versus Board of Education enforced. No one's helping us. Not Congress, not the president. We decide this one now because we're going to have to say it's unconstitutional. That's what they're afraid of in the South a lot. We'll never get it enforced. Postpone it. They did postpone it. They postponed it till Loving versus Virginia. And then eventually they said, in Loving, they said it's unconstitutional to forbid miscegenation. And then that's political. I can't say never. And, well, there's what Paul Freund said, and I've always thought that this is absolutely the most accurate if you can understand it, and nobody can. But nonetheless, this is what he said, and it's pretty good. He was professor at Harvard, constitutional law for years, and great professor. He said, politics, look, all right, that no judge decides a case based on the temperature of the day. But all judges are aware of the climate of the era. How did we get from Lochner over to the New Deal? Lochner, the country had grown rich on laissez-faire contract property. Richest country in the world, 1920, 1950, 1900s, getting there. The poorest in the world, just about, at the time of the Civil War. Reading a pretty good book about that called Lincoln on the Verge, his trip from Springfield to Washington. Wow. Wow. The country changes over time. The season, the era. Yeah. Okay. And there's what Taft wrote to Sutherland. Taft, who had been president of the United States and is now Chief Justice of the Supreme Court, writes in a letter to his colleague Sutherland, he says, I hope appointments, new appointments, and Holmes is on that court, and Brandeis is on that court, and he says, I hope that the new appointments, of course, know something about law. He says, it's a legal job. Good point. He says, but I hope they also know something about what he said was the higher politics. And just what is. Well, that's what I've been trying to figure out. I mean, and it is different on the Supreme Court than on the lower court. It is. Are judges on that court aware of what people are thinking? Of course. Of course. And how does that affect their opinions? When I get the answer to that, I'll know what Paul Freund meant. Yeah. But is it there? Yeah. And is that just doing things politically? No. And does it mean often politically? No. Well, what does it mean? Well, I'll leave you with that question. I don't have a really good answer to it, but I do think it is one of the three branches of government. That it is. And it's in the Constitution as one of those three. And people are aware of that. What does it mean to be aware of it? The Taft Court was a pretty good court.
How many, can I ask, in the audience, how many of you are law students?
Oh, good.
Okay. And how many of you would like to clerk at the Supreme Court?
Oh, come on.
Oh.
Liars, liars. It's okay, it's okay. So
Well done. Well done.
I want to come to Risa and the Justice because you both were clerks at the court. And Justice Breyer, you were a clerk for Arthur Goldberg, and people don't know a lot about Arthur Goldberg. And
We loved him. I'm giving you a hint what the answer is.
Yeah. We love him.
He was, yes, he was lovable, as I understand. And I'm thinking about it was a concurrence in the Griswold case regarding privacy, and his very expansive view of the Ninth Amendment. And how does your book and your approach relate to that?
Well, it's consistent with that, but it's one of the book to read on that, what did the founders really think when they wrote this? What's his name? I don't pronounce it correctly.
Jonathan Gnapp.
Yes, Gnapp. All right. I just read that. He's written a book called Against, I'm just trying to, all right. It's called Against Constitutional Textualism or Originalism.
Yeah.
Originalism. And he goes back to the founders, and he's a pretty good historian, I guess. I would think so, the historian, yes. And he said that they had no idea of what this thing, the living Constitution, is. They had no idea what originalism is. They thought and did divide over the question of whether the words, as Marshall writes in McCullough versus Maryland, whether the word should be interpreted broadly or narrowly. And there is that word liberty there. How broadly? And so when we wrote that, I did work on that.
I thought I remembered that correctly.
Yeah, and but the Ninth Amendment says the fact that there are some listed here doesn't mean there aren't others. Well, what others? What others? And are they others? Or are they part of liberty? And Goldberg would say, do you know the only person who violated the Ninth Amendment? Say who? Right, well, it's Justice Black. Justice Black said she's very literal in all these things. And this was way before. I mean, this was a long time ago. But how far do you go? And there is no clear answer to that. There is no clear answer. But the framers, that's some piece of evidence, among many others that he has, that the framers, many of them, did think a broad interpretation of many of these words was appropriate. And I think it's unfortunate, though others disagree, that Blackmun so frequently in Roe used the word privacy. So you don't know how I proved that with my class the other day. I said, what word would you have used when you were writing Casey? What word would you have used? Would you have used no? I mean, what word? Liberty. Why liberty? Equality. Try that. Try the fact that in 1868, I would say, I'm being slightly funny in saying this in class, but I said, wasn't there a group of people who didn't really participate in the political process? I wonder what they were called. And I said, what about talking about the rights that they might have? or the needs that they might have, or the lives that they might lead, and why they play important roles in this word liberty. And if you read Casey, that's what I think was Sandra's part. I think it was Sandra O'Connor's part of that opinion, where it's certainly written there. Certainly written there. See, and you track the need for a woman to have the right to choose as part of the liberty that this Constitution gives to her. You don't have to be tricky. You don't have to be complicated. You don't have to be anything but just saying it isn't true anymore. A woman's place is in the home. The person who liked to say that all the time was Ruth Ginsburg. and she did. And it was good. So in any case, of course, but how broadly? How expand? How? When do you begin to fall into the trap that Alito sets in Dobbs when he says, and the judges are just putting what they think is good for the society instead of the law? You don't want to do that either. That's difficult cases, and when you have a difficult, that's the job. That's the job in some instances. How? Well, this book, one thing among many, that discusses that. And why is that? Personally, it becomes important. If you want to ask me, what is the most serious risk the job of a Supreme Court justice? The president said this. He said, you'll discover something. You will discover that the applause dies away very fast. Very fast. Much faster than you think. And you're left with the job. You better like it. And what it does, what it gives, the privilege of having it, is you have to devote your best to each case that comes up. And as you get older, that's a more privilege. It is a privilege. And that's what it is. I'm at a reception where there's some young lawyers, and one comes up with his friend and he says, oh, Justice Breyer, I think your opinions are so wonderful. I love to read them. Would you sign my programs? I said, of course, I sign his program. Okay, so he turns around and goes off with his friend. And as he goes off with his friend, he turns to his friend and he says, that makes 4.
In the minority, then. We have some questions that have come in from our audience, both I think in person and online. Emmy from Illinois has an interesting one. And she says, is there any decision that you lost sleep over as you were contemplating how to vote and how to write an opinion? And she says, including where you didn't join the majority. And then she asks the most important part. If so, could you say a few words about which cases and why?
No, the problem of answering it is that I forget. You see, it's that the rules, the two unspoken rules. No one in conference speaks twice until everyone speaks once. It's a very good rule for a small group. The second is, and Sandra said this so many times, tomorrow is another day. Maybe we did decide this case wrong yesterday. Or maybe you lost. Maybe you were in a dissent. Probably 40% are unanimous. There weren't that many, 5, 4 even. But maybe you were. Okay. And Goldberg said this. What are you going to do? Sit around and complain nonstop? No. You go on to the next case and try to get that one. You get that one right, try to get that one. So you want a particular case that I would have decided differently on? I mean, there are some. Oh, I think I would have decided differently if I were doing, and I did lose sleep over it. Didn't lose sleep. I never lose sleep, but nonetheless. But the case, the cross-examination, where Nino convinced me of that, that the Sixth Amendment, you have a right to cross-examine, you have a right to, and I think I learned because they'd written loads of scholarly articles about why the previous decision was wrong, whatever, and do you have a right to confront the witness? And the answer is sometimes you do. So I knew that when the court had said you don't, they're wrong. But what's the substitute? And I thought Nina was going to put in sometimes yes, sometimes no, because after all, they all know, because there's a thing called hearsay. If you don't know hearsay, you better take evidence immediately. All right, and there are exceptions to the hearsay rule. And so what about those exceptions, like business records, hospital records, all kinds of things go in that, and witnesses in court. What about a dying declaration? Smith shot me. He said, can you bring that in or not? Well, I think they took that and went too far with keeping things out. And so there's one. Okay. And I'm sure there are plenty of others.
Well, there's another question from our audience about constitutional amendments. You talked about the 9th Amendment and the 2nd Amendment. If you could wave a magic wand and amend the Constitution today, what would you do?
Not sure. Why? Well, in San Francisco, in the 30s, they wrote a pretty good charter. It had a city manager, and it had a mayor, and it was a good charter. It worked pretty well. But being worried that it might not end up perfectly, they provided that in the 70s, they'd revise it. A committee had to be elected to revise it. My father decided he was going to run for that office. And he did. And he got on the committee, and the committee went and met to revise the charter. Came home, I just remember when he came home that evening. He said, well, what was that like? Was it good? Oh, it was terrible. I said, why was it terrible? I said, because I know what we should do to revise the charter, but everybody disagreed. Everybody had their own favorite thing. So I don't know what would happen if you start doing this. You say, you have to be careful. Look what happened in Chile. Everybody wrote his own favorite thing, and then the whole thing got rejected, and then they're doing it again. I don't know. I mean, you don't know what will happen when you start mucking around with this. It may be just the things you don't want. And so I'm nervous about it. That's why I can't give a clear answer.
All right, this is about a technical issue for us political scientists and non-lawyers, and it begins, as one of the court's foremost antitrust experts, what is the most exciting thing about antitrust issues?
They're very interesting. They're fabulous. I used to think they're sort of like the Constitution, but not quite. It's what we have, and we did used to have that. I think we grew up after World War II, when I was a child. Then we had Marshall. And the Marshall Plan. And what were we trying to do? We were included Germany in that, and the countries in Europe. And we had sort of basic values. One of them was against communism. Against, but it was right? Quality, rule of law. Let's work out international problems. Free trade. That trade part was there. Probably they called it freer trade. This is fine. Other institutions, to bind them economically as well as from the point of view of human rights. Okay, when I worked in the antitrust division, which was great, with Don Turner, the economic theory of the country was competition, yes, but policed by antitrust. So companies would either not do, or they wouldn't be so stupid as to leave the memo in the file that which Roger Fisher found, or one of my professors, when he was working for a firm, the memo that said, burn this memo, price fix it. My brother had a case sort of like that, and he had a client, he had a defense, he was defending a businessman from a charge of what is it, bribery of foreign officials or something like that. And I don't know if I should tell it. But he said his hardest case, he was defending him, and the prosecution had a memo that this guy had written that talked to the person, his colleague, who was talking to somebody in South America. And it was the memo passed back by the person, and it said, "Can't talk now, bribe." So I said, "How did you win that case?" He said, "My colleague noticed that the judge wasn't listening." And he moved for a directed verdict. So don't do that if you're a judge. All right. In any case, this is antitrust, policing, a free enterprise economy, and where antitrust doesn't work, we have regulation. Regulation not for everything. I didn't think it was for the airlines. I thought it was keeping prices up, not down. And but it is for a lot of things. Try health, try safety, try the environment. And so try patents, try copyrights, try trademarks. There are a lot of areas where you need regulation in order to maintain the kind of economy for all, if you like, slogan there, but that competition would bring about if it could work in this area. And that was terribly visible and important in that economic area. It was fun to work in antitrust. It was fun. Also, I have to admit, at that time, in most of the countries of Europe, where we would go once a year to have an antitrust meeting in Paris, I got to go because Don Turner asked me to. I was his assistant. And the first question was always, where do we go for lunch?
Well, speaking of which, if Henry were here, he would say, we must now draw the line.
I'd like to say, can I say one thing?
You absolutely
You
may.
have to ask me this question.
Oh, please.
No, the question is why do I remain optimistic? Because we know perfectly well that underlying the conversation we've just been having, all kinds of problems in this country. And this is something I've told groups of law students and lawyers, because they can, I think, help here a lot. And we're back in the 7th grade. And now maybe they're not looking out the window so frequently. And one of them will say, well, what can we do? And so, you see, we know what they're referring to about such bitter arguments and so forth. And I tell them, and I think it's worth repeating, which is why I say that. I tell them what I learned from Senator Kennedy, this particular thing, what he would tell his staff. He would say, don't worry about credit for things. He says, you succeed at something, plenty of credit to go around. You fail, who wants the credit? But he said, this is what you do. You're having trouble getting a bill passed or stopping a bill from passing, whatever it is, and there are people, maybe Republicans, maybe Democrats, but there are people, they disagree with you. Here's what you do. You do what John Stuart Mill, I think, said the same thing. You find someone who does disagree with you. You think that person is intelligent, and you sit down and you talk to them. Wait. Don't talk too much. Listen. Listen to what they say. And if you listen long enough, they will say something that you honestly agree with. And as soon as they say that thing you honestly agree with, you say, that's a very good point you made. Okay? Let's see if we can work with that. And then you try to work with it. And maybe you'll succeed. Succeed at what? If you get 30% of what you want, great, take it. Don't hold out for 100%, which you don't get, so all your followers say you're wonderful. No. Take the 30%. And then you've gotten somewhere. And I saw him many times. The press would say when we're successful at something, Senator Kennedy, you did such a good job on that. And he would say, don't thank me. Thank Orrin Hatch. Thank the Republicans. They came up with the thing that allowed us to work together and to get whatever this thing was. Now, it isn't what I've just said that makes me optimistic. What makes me optimistic is the fact that they're not looking out the window. They're not. They're looking at what I'm saying. They're looking, and it's the look in their eye in that 7th grade, where I can see they think we found something where we can be helpful. We found something that we really can do something, and we can try. And it's that 7th grade, the light in their eye, their desire, that makes me still pretty optimistic about the United States.
Thank you all for being here and honoring Professor Abraham's memory, and most especially thank you, Justice Breyer, for your service to our country, which you continue by speaking and writing, and we hope to welcome you back soon to Mr. Jefferson's University. Thank you again. Because we know you're here because of Risa, so we can't thank you enough.
Thank you.